Testing, 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 testing. Testing, testing. Testing, testing. We should be good. I don't know what happened back there, back then. Apologize for the mishap. I had a beautiful intro. Just make sure everything else is functioning properly. Okay. All right, that's great. I don't know what happened a second ago, but nonetheless, we're gonna start this one over again. Hopefully, we don't have any issues. Greetings, Countess Middleton from the House of Middleton. As always, we have our anthem. Return of the King. There comes a time in the tale of men that the world know very well. But to them that the story is told about forever remains a tale. 6,000 years has come and gone, and man is none the wise. The hour that's come has fate untold. What's follow is man's demise. Return of the King, return of the King, make way, make way, make way. Return of the King, return of the King, wherever where he may reign. Time waits for no one, but everyone subject to time. From tales of gods to tales of men, therein your answer will lie. Return of the King, return of the King, make way, make way, make way. return of the King, return of the King, wherever he may reign. Greetings, 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 greetings. I desire King Clifford Jefferson, a Senator Godfrey the Fifth Caliban Jew, son of folk, ruler of Jerusalem. I am the reincarnation of King Edgar the Peaceful, which we know here at the Third Temple English Church of England as Jesus Christ. I give honor to my Queen Sister Galveston from the House of Galveston. I give honor to Archbishop Belmont from the House of Belmont. I give honor to all those brothers and sisters who are all trying to get an understanding of what it is that we are here and are called to do. This is called Part 2 of the Doomsday Book 2025, The Days of Judgment. Thus says the Lord. Part 2 of the Doomsday Book 2025, The Days of Judgment. Thus says the Lord. I had recently did a lesson not too minutes ago, but apparently we had some technical problems. But once again, nonetheless, I'm back again. So greetings, Countess Middleton. Once again, glad to have you. This will be a marvelous lecture, part two. Today we're going to take our time. Okay, we're going to take our time with it to really home in on some key points that no matter how many times we go over this, we as a people always seem to miss. Okay, we always seem to miss, and your salvation depends upon what it is that I'm saying to you today, because everybody wants to believe in, wants to talk about, wants to validate the belief of some coming Messiah or some person that was supposed to come back and return you back to the state of what your ancestors were prior to them being in the state that they now exist. And that means going back to the time of our servitude. And, you know, it's very important for us to have a clear understanding about who we are in regards to our inheritance, because who you are determines your inheritance. All right. And sometimes us as subjects lose our inheritance. Sometimes we as citizens lose our inheritance. Sometimes as foreigners we give up our inheritance. There are many ways that inheritance can be abandoned, but the way it's being done would not suffice. Okay? It will not suffice. So this is for all you judges, for all you lawyers, for all you councils, for all you legislative, executive, judicial officials in your official and private capacities. Today is Doomsday Book. Okay? Today is the Doomsday Book, 2025, the days of judgment. Thus says the Lord. It's not going to happen in one day. It's going to be an unfoldment of events. Okay? The books are now open. Okay? January is the symbolic of the god Janus, which means the double face, the door, the two doors. All right? So it's very important for you to comprehend what it is that we're talking about, because your very salvation depends upon that. Okay? We were discussing uh, the documentation that we have filed at the Chancery Court, uh, which we're going to go back over now since we had that interruption. Hopefully that won't happen again. But, everything that we do here, we want to make sure that the subjects definitely see it. So this is not a wishing upon a well where we go and throw some coins in the well and hope whatever happens comes true. No, we make our own fruition. Okay. Middlesex County docket number, Chancery Division 00143-24, filed uh, uh, December 3rd, 2024. December 3rd, 2024. Okay? King Clifford Jefferson and the Crown of England. versus the state of New Jersey and New Jersey Land Title Institute. The complaint was filed on the premises that the plaintiff submits this complaint on the grounds that the selection and appointments of the defendants is a violation of provisions of Article 22, Article 23 of the 1776 Constitution, Article 10, Section 1 of the 1844 Constitution, and Article 11, Paragraph 1, Section 3 of the 1947 Constitution of New Jersey. And as a result of that, they have violated their oath because it also states in those constitutions that every person who should be elected as aforesaid to be a member of the Legislative Council or the House Assembly shall, previous to his taking his seat in that council or assembly, taking the following oath of affirmation. Okay, for that reconciliation between Great Britain, and once that reconciliation was done, the charter in which they now invoke under the 1776 Constitution, 1844 Constitution, and the 1947 Constitution would can be considered null and void. Why? Because now the government must be taken by the crown, and the crown representative, which would be me, which would be the monarch, i.e., the king. Okay? Very important to understand those basic concepts, basic terms. Plaintiff is entitled to relief from the defendants under the above facts. The harm occurred as a result of the defendants' acts, which include on April 18th, these are my actions acting in my judicial capacity, which is a necessity, which is justified. Okay? It's justified under what we call the laws of necessity. And the laws of necessity in English common law involve torts under the common law, which means trespass of property, land, and conversion of that property and land. Okay? To transfer of that property and land. All right, which is also property, movable and non-movable. Okay? So on April 18, 2022, at 11:37 a.m., King Clifford Jefferson presented and filed with the county clerk, Don Domino, a certificate, i.e., our charter of the Third Temple English Church of England and the heirs of successors as a corporation sole. Our certificate of incorporation of the Third Temple English Church of England and the heirs and successors were filed as a corporation sole pursuant to the Georgia Revised Statute 16.1-28, where it says that rights saved under charters of Great Britain are saved from repeal. Okay, an act to incorporate trustees of religious society for property being held in corporations and place thereof. Okay, that section vests their property under charges of incorporations and place thereof. That will be what we call the state of New Jersey. On Tuesday, His Majesty called the county clerk's office to inform them that I would be visiting the clerk's office on February 20th as well as the 21st and 2024 to file a religious deed pursuant to 46:3-2 of the said statute of New Jersey. And the deed is not a deed of ownership, it's a deed of conveyance. Okay? A deed is nothing more than the instrument showing acquire possession, not proof that you are in fact owner of that possession which you now acquire by way of the deed. All right. Also pursuant to 46:3-2, which states certain tenures and holdings are turned into free and common soakage, and pursuant to 46:3-6, being that the land is allodial, okay, free and clear of any encumbrance whatsoever. The deed of conveyance was customary practice of the lottery of season of the property situated on allodial land, pursuant to Georgia Revised Statute 46:3-6. So therefore, all gift, grants, and conveyances by the state are to be held allodial for that individual who is the true owner. 1 second. Who is the true owner who owns it allodial. Federal relief is now sought by way of all federal tenures are to be abolished, pertaining to 46:3-2. All right. All federal tenures are to be abolished, and all certain tenures that were abolished now to return into what we call free and common soakage immediately as the legislation and statutory intended it to be. Okay? And return to I, the king, on in lieu of the preservation and returning back to the heirs held in intel. Okay, we see it displayed before us right now. All right, that was filed December 3rd, 2024. Now we have the order to show cause filed also January 2nd. Okay, uploaded January 3rd. January 3rd, the crown was overthrown by way of the arresting of William Franklin. The crown was overthrown on January 3rd, 1776, by the arresting of the crown governor William Franklin, the illegitimate son of Benjamin Franklin. And we understand that from William Franklin to William Livingston to William Patterson, these are all three individuals who bear the surname Williams, going back to William the Conqueror, referring to the one who initiated the conquest. Okay? Who initiated the so called conquest. This is an order to show cause. This was showed to you in my last lecture. For all those who didn't catch that, please go back and review it. Okay? What I'm requesting from the Chancery Court is an interlocutory injunction on the state of New Jersey as a result of the criminal matter that they filed against me based upon a pseudonym, which is the name Clifford Jefferson, to take the place of the actual person, Clifford Jefferson, who I really am, based upon me being what we call a English national. Not just an English national, but a subject of the English nation. And not just a subject of the English nation, but the head of the English nation as per Ren's patriarch, i.e., the father of the nation for the English people here in what we call England. Okay? That conveyance, that transfer, that reversion cannot be done if the state still identifies me by this pseudonym known as Clifford Jefferson, which has nothing to do with Clifford Jefferson, who is an English national. Okay? So therefore, an interlocutory injunction needs to be filed on the criminal complaint that the state brought against me until the identity of the person known as Clifford Jefferson can be established, which is already established on the public record pursuant to 47 colon 1A colon 1 dash 47 colon 1A dash 1 of the New Jersey Revised Statute. Okay? Very important to understand that these are all evidentiary facts that are already presented on the court record from the public record. Okay? On the court record from the public record. So now, an interlocutory injunction is warranted as a result of the pseudonym that is assumed to be me, all right, as a citizen of the state of New Jersey. And for that to be, New Jersey, i.e., the defendant must provide that evidence, such as providing the N Form 400, which all citizens of any state must provide to be a citizen of that said state. And C, an interlocutory injunction of all recording of any deeds filed in any court of record in any county of New Jersey. Okay, an interlocutory injunction of the recording of any deed. All right, pursuant to New Jersey Bar Statute 46 3-2. Okay. And the granting of any such other relief that the court deems equitable and just. Hold that thought. Once again, this is not for you. This is for me. I'm in court right now. You sitting in the king's court. So everything that I'm doing is just repetition. Okay? So I can be able to articulate and be able to be on the frequency that I need to be on. Okay? So this is what I'm requesting from the Chancery Court, which was reviewed by the supervisor in the Chancery Court, which apparently took them 2 hours. I mean, part myself actually took them an hour to review before it was even docketed. I'm thinking they wasn't even going to file it based upon what I'm reading. Okay, based upon what she was reading, I didn't think she was going to file it, but she filed it. This is the docket number. You see it right here. All right, versus me filling out a document and posting it and talking about it. This is a document that I filled out and was actually filed. Okay, and now we're able to talk about it. Why? Because it's now a live action. Okay, and the basis of this live action, not excluding the original transfer complaint filed December 2nd, this is a order to show cause a month later. Okay, a month later, not counting the days that it takes to respond to an actual complaint, excluding weekends. So it would be further out. Okay, but it says that an interlocutory injunction on of any land conveyances situated in New Jersey. Pardon, so I missed something. An interlocutory injunction in the matter, i.e., the criminal complaint filed by the state against I, your king, based upon a pseudonym for an actual person, i.e., the all capital letters that is established in what we call the standard ID, i.e., the driving license. That instrument is not properly used to identify a citizen, i.e., national, or what we call a foreigner. Okay, it has nothing to do with Title 8 of the United States Code whatsoever. And it wasn't supposed to be used for any investigation, citation, um, uh, what else? Arrest, investigation, nothing whatsoever. That instrument was not supposed to be used. So therefore, an interlocutory injunction is warranted because not because I want the judge to do it, but because the language of the statute dictates it needs to be done. All right, until they can actually establish who I am. Am I if I'm who they say I am based upon what the standard ID said, and it said I can't be what they say it is on the standard ID because it says on the ID not for identification purposes. Okay? So if it's not for identification purposes and you're not supposed to arrest me or investigate me, cite me, um, or what is the other? Let me just go to it real quick. This is the basis of the order to show cause. Now, the supervisor of the clerk of the Chancery Court read this, took her an hour. This is the If you read the third page, it would have been alarming. If you would have got to the third page, it would have been alarming. This is the brief. If I'd have read the actual order to show cause and the language on the order to show cause is what prompted her to review this complaint based upon what I requested in lieu of the interlocutory injunction on the state of New Jersey and which she works for. Okay? This must have been scary as hell to her to actually have to file this. Okay? So it says that under New Jersey revised statute governing standard instrument known as the New Jersey Standard ID, it says that it states under the revised statute 39:3.-29.3, it states that any document and personal information, including an applicant's photograph, obtained by the commission from a applicant for a standard identification card, should be confidential and should not be considered a governmental record. I've been over this plenty of time, and people keep ignoring this fact. So when the time comes for it to come and be presented in front of you, Don't come running to me. The law is the law. Okay, I'm warning you now. All right, do not come running to me because I'm gonna have the same leniency that they have with they're gonna have. Okay, I'm gonna have the same leniency. Says third, so any document, personal information, including the applicant's photograph obtained by the commission from an applicant for a standard identification card should be confidential and not and should not be considered a governmental record. That means anything that you got that's not from the state that you created on your own, that's not a governmental record, will not be considered as proof of identity. Okay, here in North America, because if you are in fact a descendant of some nation, you must trace your descendancy to that nation and that nation's law. I hope I'm being loud and clear. I hope I'm being loud and clear. Because what Donald Trump is doing, I'm going to do the very same thing. And that might include Donald Trump. Okay? Very important. Or the common law concerning access to government records. So anything associated with a driving license has nothing to do with a governmental record and should not be disclosed by the commissioner of the DMV. I notice that word commissioner for any purpose related to Title 8 of the United States Code without the informed consent of the applicant, a warrant signed by a state or federal judge, or a lawful court order or subpoena. Guess what? They have given their consent. They have given their consent to do the below, uh, to do what they said that you can't do below. Which let's read it now. It says possession of a standard identification card issued pursuant to this section should not be considered evidence of an individual's citizenship or immigration status and should not be used as a basis for an investigation, arrest, citation, prosecution, or detention. This is what they did to me. They arrested me, investigated me, cited me, prosecuted me, and detained me. But it's just said here, you're not supposed to. So if they're doing it to me, guess what? They're going to do it to you, and they're going to continue to do it to you until you request an interlocutory injunction on the state until they can properly identify you. If everyone understands what I just said, please give me a thumbs up in the chat line. The state of New Jersey has violated the provisions of the above section by using the standard ID for exactly what the statute forbids, which warrants an interlocutory injunction on the state of New Jersey via the statutory language alone. Okay? So if the clerk got that far, if she actually got that far in that complaint, and she read this in lieu of that brief, I.e., the complaint, then I will be shaking in my damn boots right now. I will be shaking in my boots right now. Why? Because the interlocutory injunction from which I'm seeking from the Chancery Court, a court of equity, a court of fairness, is a injunction on the state of New Jersey until they can actually determine who I am. So now, until the Chancery Court can determine the identity of the plaintiff versus the identity who they want me to be based upon the standard ID governed under the New Jersey Revised Statute, Title 39, an interlocutory judgment injunction should be put in place because the statute says it. If you don't do it, that means that they can arrest me, cite me, prosecute me, um, uh, investigate me all over again as long as they want, continuously, until they can properly identify who I am. Not just me, but you as well. They need to properly identify you. They knew who I was prior to them locking me up because of what it is that I was trying to do, which was revert the land back to the heirs. Okay? So if I'm not who I say I am, then I'm who you say I am, then that means you need to provide evidence that I'm in fact a state citizen, and that providing the N-Form 400. The N-Form 400. Okay? Until that's done, I need an interlocutory injunction, a recording of any so-called deed filed in any county, in any state, in any county of all counties within the state of New Jersey. Why? Because in the county of New Jersey, in the counties of New Jersey, all land is allodial. Okay? All land is allodial under 46:3-6 of the revised statute. I didn't make that up. The statute says that. Okay? So it's further ordered based upon my request to the Chancery Division that an interlocutory injunction of any type of land conveyance be stayed situated in New Jersey. Why? Because the land is what? Allodial. All right? If the land is allodial, that means that there should be no tenures, whether they're feudal tenure or just tenure issued by the so-called owner. Okay? If the land is allodial, that means free and clear of any encumbrance. I also ask for an interlocutory injunction until the intel heirs are confirmed to that land that's situated on that allodial land. Okay? Pursuant to Quint Imperatoris going back to 1290, because that was the law put in place to stop the alienation of land that was intel based upon de donuts conditionalibus, the statutes of intel, and an interlocutory injunction and temporary restraint on all income deriving from that adverse position. Did you hear that? This is what the senior clerk in the Chancery Division took an hour to review of what you're reading, as well as the brief. They took an hour. This must have scared the living hell out of her. Why? Because she filed it. She filed it. Yes, she filed it. You see the docket number right there. So this is no joke, brothers and sisters, what it is that we're doing. This is no joke. All right. So why is it important for me to do what it is that I'm doing? Crown land. Crown land, also known as the royal domain, is a territorial area belonging to the monarch who personifies the crown. It is the equivalent of a entail estate and passes with the monarchy being inseparable from it. Okay? Passes with the monarchy being inseparable from it. So if that's the case, that means that we must go here to New Jersey's Land Title Institute. If the king represents the crown and the crown is called crown land and personified by the king, which is inseparable, we need to go back to the origin of the crown. Not just abstract talk or just some talk about the kingdom of England and the crown, but the actual territorial limits where the crown was actually situated, i.e., the seat of the government. The seat of the government. And this is from New Jersey's Land Title Institute, which states that the New Jersey, not the New Jersey Land Title Institute, but New Jersey was formerly a colony of the Crown of England. You hear that? Because New Jersey verifies that New Jersey was formerly a colony of the Crown of England. The history and development of our entire legal system, including our system of land ownership, began with the successful invasion of England and the crown of England by the successful invasion by the Normans in the year 1066. So the state of New Jersey is aware of the history of the Kingdom of England under the authority of the Crown of England and its entire legal system, including land ownership, which has its roots in England, but for their purposes and their intent, how they came to acquire the land and the development of the land in lieu of some type of interest in the land that they call ownership, be simple, begin with the successful invasion of England, New Jersey, as well as the whole damn landmass, all right? Didn't start till the Normans invaded England in 1066, which New Jersey is admitting, they are actually admitting that their entire uh, uh, um, way of ownership of land was based upon the successful invasion of the Kingdom of England under the authority of the power of the Crown of England, going back to William the Conqueror, who invaded England. Wasn't living in England, but invaded England. That means that England had to be right here. Okay? From 1066 till 1776 and on up to this present day. England had to be here because those people who were living in those colonies knew that this was England under the authority of the crown. They knew that going all the way back to the successful invasion of William the Conqueror because they are the successors of William the Conqueror. If everyone understands that, please give me a thumbs up in the chat. Give me a thumbs up in the chat. By way of an illustration, let us assume that the entire nation of England, so they're not talking about just the colony, they said the entire nation means the entire country of England was one huge tract of land. That means allodial land. That means allodial land. The king, they remember when they colonized North America from the east side, it was by way of the Danish, what we call New Netherlands, back to the restoration of the crown under King Charles II. Prior to that, it was under the authority of the prior monarchs of the House of Stuart, going back to what we call King James VI of Scotland. Okay? King James VI of Scotland. So all of those issues, all of those events that were taking place from 1776 going all the way back to 1066 happened right here on this landmass because New Jersey just admitted it. They said that for their purpose, the land ownership or how they acquired land ownership did not develop until the successful invasion of William the Conqueror in 1066 under the laws of conquest. Okay? This is the same process that William Franklin did, William Livingston did, and William Patterson did. You are what your forefathers are without doubt or contradiction. William Franklin had to take the heat for his father. He was a representative of New Jersey, so he has to take the heat for New Jersey. Governor Murphy, the Attorney General Matthew J. Plankin, and every officer who were and authorized to act in that capacity in which they're acting now has to go down with them. Okay? We must understand that. We're talking about the Crown of England. And we know that Crown land is Intel Estate. Intel Estate. Okay? Crown land. Crown land, also known as royal domain, is a territory area belonging to the monarch who personifies the crown. It is the equivalent of a entail estate and passes with the monarchy being acceptable from it. So I have your inheritance with me. How I know it, just look at the Kingdom of England. The Kingdom of England, i.e., the Crown of England, known as Crown Land, was a sovereign states or crown states on the island of Great Britain from early 10th century when it was unified from the various Anglo-Saxon kingdoms. Let's go. Early Anglo-Saxon kingdoms. All right. Until May 1st, 1707, when he united Scotland to form the Kingdom of Great Britain, which would later become become the United Kingdom. So this didn't come till 1707. New Jersey just said that New Jersey was a crown colony of the Kingdom of England going all the way back to 1066 and prior to that until it was overthrown successfully by William the Conqueror in 1066. Okay? Now, I find that story somewhat fraudulent for the simple fact that the crown government is already situated here in 1702 in New Jersey. The crown government is situated here in New Jersey in 1702 before 1707. Okay? But New Jersey says that their success in ownership of land did not come until the successful invasion of William the Conqueror in 1066, which according to that, up until that time, that statement, the invasion of England and all those kings of England and all those who invaded England as kings was a myth. But New Jersey just validated that their acquiring of land ownership did not come until the successful invasion of the Kingdom of England. And then they brought William the Conqueror in it. So they're validating that they got some kindred to William the Conqueror. Williams who conquered, those with that surname who conquered, because the surname William goes back to William the Conqueror. Okay? So we see that the crown of England was here in 1702 before 1707. Here, here. Beginning in the year 886, starting with Alfred the Great. All right? We know Ethelred Ashleton, where the twig and twirl ceremonial derived from, in lieu of what we call lobby of season, mentioned Ashleton, the grandson of Alfred the Great, the son of Edward the Elder, the son of Alfred the Great, and his wife Ilswith. Ilswith. And we know they're dark skinned. Let's see if they show his wife. Probably not. They don't show her face now. They used to show her face, but they don't show it now. All right, so as we can see, Alfred the Great, Edward the Elder, Atherton were all great kings of the kings of Wessex. All right? And we're talking about the kingdom of England. Okay? The kingdom of England. Okay? If you look at the map to your right, if you're on the computer, it says location of the kingdom of England in 1558 to 1707. Okay? From 1558 to 1707. But yet the crown of New Jersey is situated here in 1702. Let's look at that. Somebody's lying. His Majesty's Council for the province of New Jersey was. Didn't they say that New Jersey was a colony of the Crown of England? That's what they said in the evidence that we presented to the Chancery Court. His Majesty's Council for the province of New Jersey was the upper house of the New Jersey legislature under colonial rule until it was replaced by New Jersey Legislative Council on New Jersey's Constitution of 1776. The length of term was indefinite. Authority, the crown. So that means that the authority of the crown and where it's located at was indefinite. You're right, but only big lies. It was indefinite. How we know it was indefinite? Why? Because it goes back to Alfred the Great. The Provincial Council was established in 1702 upon the surrender by the proprietors of East Jersey and West Jersey of the right of government to Queen Anne. It had always been here. It was just overseen by de facto monarchs going back to the House of Stuart. All right? And that didn't originate until it was passed to the House of Stuart under what we call the Elizabeth Religious Settlement, which we're going to discuss today, my brothers and sisters. All right? The instructions from Queen Anne to Viscount Cornbury, the first royal governor, i.e., regent of New Jersey, outlined a fusion of power system, which outlined for an overlap of the executive, legislative, and judicial authority, and provided the bicameral legislature consisted of a council and general assembly. That's New Jersey's provincial council, which the government was sitting and functioning with the representatives of the government functioning under the authority of the crown by the authority of the king right here in New Jersey, now called New Jersey. Prior to that, it was part of what we call the Channel Islands, under the authority of the kings of the Plantagenet going back to Henry II. Okay? We must comprehend what's being said. Let's go back to the Kingdom of England. So we know what we read from now on is a lie. Okay, so whatever we read now is a straight up lie. Okay, how? The next paragraph tells it all. So let's read it. Let's go back to the article again, so we can know that when it comes time for the state of New Jersey to justify how they came in possession of this land, the entire landmass called the nation of England, they got some explaining to do. I would not want to be in the position of the Attorney General right now. Because New Jersey was formerly a colony of the Crown of England, the history and development of our entire legal system, including our system of land ownership, has its roots in England. For our purpose, though, the development of land ownership, not based upon the legal system of England, but based upon how they acquired land ownership from of the origin of land ownership, which is rooted in England, their purpose and intent developed at its height, going back to the successful invasion of England by the Norman invasion in the year 1066 under the leadership of who? Everybody said William the Conqueror. So if that's the case, let's go back to the Kingdom of England. History of the Kingdom of England from the Norman conquest, keeping the article we just had in mind. Keeping that in mind. Okay? Don't lose focus on that article, brothers and sisters. Because New Jersey just validated everything from William the Conqueror till now, which includes everything between that time. So there's a gap in history that's a mystery to y'all but that you need to remember. If it's not part of history, so be it. But for the purpose and intent for your inheritance, you better be a part of this gap in history. Because if you're not, you're in a world of trouble. If everybody understand what I just said, please give me a thumbs up in the chat. So let's look at that gap of information that will fill in all the information of everything else that happened from before until the present. Remember, we talking about past, present, and future? Let's pull it up. Engrams. Three dimension. No, time and space. Part itself. We're coming from astronomy term. Time and space. Or space time. Because you're living in space subject to time. Okay? Living in space subject to time, known as space time. So the time your ass has been living in that space that you call a body. Come on now. I'm going to use this space-time, past, present, and future. All right? Your past, your present, and future is based upon that gap from William the Conqueror until now. Prior to William the Conqueror, we was good. We were immortals. Prior to that time, our ancestors have existed throughout time, immortality. Anglo-Saxon Berbers. All right? Space-time. In physics, space-time, also called space-time continuum, is a mathematical model that fuses the three dimensions of space and that one dimension of time into a single fourth dimension continuum. Space-time diagrams are useful in visualizing and understanding relativistic, relativistic effects, such as how different observers perceive where and when events occur in the so-called universe. All right? Past, present, future under the same time continuum. What is time? Past, present, future. An irreversible events. Let's look at it. It's our time, my brothers and sisters. Nothing they can do about it. Time. It's a continuous progression of a change in existence that occurs in apparently irreversible succession from the past to the present and to the future. So if you got no past, you have no present, therefore you have no future. Do everyone understand what I'm saying to y'all? It is a component quantity of various measurements that had to be made used to a sequence events. This is called proposition. This is called a life experiment, okay? From your original position. Seeing yourself from your original position. It is a component quantity of various measurement used to sequence events, to compare the duration of events or the intervals between them, and to quantify rate of change and quantities in material reality or in the conscious experiences. Time is often referred to as a fourth dimension along with three spatial dimensions. Scientists have theorized a beginning of time in our universe starting with the Big Bang. Do everyone understand what I just said to them? Based upon time. Not what you want time to be, but what time is based upon who you say your ancestors was in the past, all associated with time. Okay? So with that, we go back to the Kingdom of England. Because we are what our forefathers were without doubt or contradiction. If we remember our past, we understand our present, and then that will prepare us now for the future to not repeat the past that we forgot as a result of our ignorance. Okay? History of the Kingdom of England from the Norman Conquest of 1066 from the mouth of New Jersey. According to New Jersey's claim on how they acquired land when William the Conqueror successfully invaded the Kingdom of England, which originally must have been here if New Jersey was just a crown colony, as they state. All right? So imagine them talking to me. It's like talking to God in the face. Because I was here before their history started. I was here when their history began, and I will be here when their history is no longer. History of the Kingdom of England from the Norman Conquest from 1066 conventionally distinguished periods named after successive ruling dynasties. Normans, the Angevins from 1066 to 1216, the Plantagenets 1216 to 1485, the Tudors from 1485 to 1603, the Stuarts from 1603 to 1707, interrupted by a short interregnum from 1649 to 1600, All English miners after 1066 ultimately descended from the Normans. Did you hear that, my brothers and sisters? Did you hear that? I didn't put this in Wikipedia. They put it. All English miners after 1066 ultimately descended from Normans, and the distinction of the Plantagenet is conventional, beginning with Henry II, son of Godfrey the Fifth, Count of Anjou, son of Fulk, ruler of Jerusalem. And as from that time, the Angevin kings became more English in nature. So, what nature was there prior to them becoming English in nature? Let's look at it. 1065, a year before 1066. Who were we? What were we? And how can we prove that existence? Boy, every brother and sister, mama and daddy, aunt, uncle should be reviewing this lesson. 1065. French and the Spanish houses were aligned with the Plantagenet houses. All right. Even the kings of Wessex were all aligned because they were, in fact, Anglo-Saxon Berbers. Whether they were in England, whether they were over here in what you call North America, whether they were on what you call the Iberian Peninsula, whether they were on the continent, what they call Northwest Africa, we were raised Berbers. Why? Because you don't see no English reading out here in 1065. But you see a Berber calendar, and the year is 2015, and the year 1065. Because we don't use the English calendar. Okay? We use the Berber calendar. The year to us today is 2975, not 2025. Boom! You right, brother. Boom! Ain't no English reading our year here. All right? But we became English in nature. Okay? As they just stated. In lieu of what we call the Kingdom of England, and that missing gap, that gap of time that's missing, but yet we got Edward the Confessor, the last king of Wessex before who? William the Conqueror invaded England. Okay? Before William the Conqueror invaded England. Kingdom of England. So after 1066, when William the Conqueror invaded England, we became English in nature. So, history of Kingdom of England from the Norman conquest of 1066 conventionally distinguished periods named after the succession ruling dynasties, the Normans. Everybody else, the only people left is us. The only people left now is us. The descendants of the House of Engleer, which is Godfrey's families. Folk the first, Folk the second, Folk the third, Folk the fourth, Folk the fifth, Godfrey the first, Godfrey the second, Godfrey the third, Godfrey the fifth. And I must be Godfrey the fifth. I mean the sixth. All right. So the history of the Kingdom of England from the Norman conquest, who all were Anglo-Saxon Berbers. All right, because they were all a part of the French and Spanish houses by the name they go by now. Okay, known as the Spanish Empire, the French Empire. Okay, yes, the Spanish Empire and the French Empire, going back to who? Louis the 14th and Sancho the Third. Let's look at it real quick. Events in 1065. Ferdinand, King of Leon and Castile. All right, this is the Spanish Empire. All right, the first king of the Spanish Empire was Sancho II. All right, going down, and the last one was Ferdinand III, the father of Eleanor of Castile, who married Edward I, the son of Henry III, the son of John, the son of Henry II, the son of Godfrey V, Caliban Jew, the son of Folk, the ruler of Jerusalem. Okay, you got Baldwin of Flanders. All right, that's a Frankish house of France. Edward the Confessor. All right, the last king of Wessex, the son of Ethelred the Unready, the son of who? Our Jesus Christ, who I'm the reincarnation of. All right, so back to the Kingdom of England. So now we know how we got our English nature. All English miners after 1066 ultimately descend from the Normans, and the distinction of the Plantagenet is conventionally beginning with Henry II, as from that time the Angevin king became more English in nature. So that means that the Angevin kings under Henry II, son of Godfrey the Fifth Caliban Jew, is where we should take our lead. This is where we should take our lead. Do everyone agree with me that this is where we should take our lead from? Henry II, the one who established the common law of England. All right? We became English in nature. The houses of Lancaster and York are both Plantagenet cadet branches. The Tudor dynasty claimed descent of Edward III via John Beaufort and James VI of Scotland, and the soon to be the first king of England of the House of Stuart claimed descent from Henry VII of Margaret of Tudor. Now, this is very, 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 very important. Very important. We must not overlook this important fact. Because from the House of Tudors to the House of Stuarts is where the problem comes in. Right? We talk about this gap of time, right? From 1066 to Henry VII. Right? This gap, which determined everything, and know what we call space time. And if it wasn't for the state of New Jersey, this truth would have never came out. If it wasn't for the state of New Jersey, None of this will ever come out. That's our proof. All right? That's our proof. How we became English in nature. Our government was still here, the crown, but we became English in nature. Our laws were here, our customs were here, our tradition was here, our people were here, but we became English in nature. Under the English common law, which is according to the 1911 Encyclopedia Britannica, said it was the law of the Berbers. Let's look at it. You can't make this up. '1911 Encyclopedia Britannica. So I'm not being biased, and you should not be biased either. The fact has been emphasized by Dr. R.T. Lefton, who writes that all that is not Arabic in the Kingdom of Morocco, all that is not in Arabic in French provinces of Algeria, and all that is not Arabic in Tunis, Tripoli, and Fezzan is Berber. The explanation lies in the profound distinction of their characteristics. The Arab is a herdsman and a nomad. The Berber is a agriculturist and a townsman. The Arab has built his social structure on the Quran, which inculcates absolutism, aristocracy, and theocracy, versus the Berber, despite his nominal Mohammedanism, is a democratic, which is Jimna or Wittemont, or his Qanun or unwritten code called the Magna Carta of the individual liberties as opposed to the common community's good. So we see that, in fact, the laws of the English, now as a result of the invasion in 1066, or actually the laws of our true characteristics, which were the law of the Berbers. Okay, if everyone agree with me, please give me a thumbs up in the chat. All right. So in order to return our estate back to the heirs, you must return the king to his position. And the only way you can do that is learn the history of your kingdom and you being part of that kingdom. From 1066 until Henry VII. From 1066 until Henry VII is what we need to figure out. It's what we need to figure out. Not pertaining to the location of the Kingdom of England in 1558 to 1707, because that's fraudulent. That's fraudulent because we know in 1707 it's right here. And it was indefinite. So from 1558 becomes suspect. Wittemont, it became Carré Regis when William the Conqueror invaded. It became what they call uh, um, the Carré Regis, Wittemont, the Carré Regis, Witten, had many names. New Jersey Provincial Council, King's Bench. It had many names that they went by. All right. But our main concern is how we lost control of our government, as well as Albion. Greetings, Archbishop Belmont. So we must find out how we lost our government, and this is this gap in time, right here. That gap in space time. All right? That gap in space time. And what is time? I mean, what is space time? So y'all get your heads out of the clouds and keep it down here. In physics, we are physical beings, right? So we must understand ourselves as physical beings from a point of physics. Physical objects, entities. All right? Physical objects. In physics, space time, also called space time continuum, still continuing that space from the state of evolution. All right? From the state of evolution, from the state prior to evolution, prokaryote, to evolution, eukaryote, to the state of our divine state, back to our etheric state. All right? Through the understanding of embryogenesis from non living matter to matter, i.e., flesh, i.e., mass, i.e., matter, i.e., volume. Okay? In physics, space-time, also called space-time continuum, is a mathematical model that fuses three dimensions of space um, uh, and the one dimension of time into a single fourth dimensional time continuum known as space-time diagram. Okay? And observers perceive where and when events occur from that perspective. So, as physical beings, this is how we should understand ourselves from that perspective, moving through space time, i.e., this body, this physical body, because the mind is not attached to the body. Okay? The mind is intangible. You can't touch the mind. Anything the mind does, the body what? Follows. It continues. All right? So going back to the kingdom of England, that's space and time. Past, present, where we are now at, to our future. All right? This is all we need to understand to determine our future. Let's prove it. Our future was all right until we got up to this point. The Tudor, which was founded by who? Henry VII. The reign of Henry VII. To secure his hold on the throne, Henry declared himself as king by what? Right of conquest. Okay? We're talking about Henry VII claimed to be king by right of conquest. We know New Jersey represented the crown indefinitely, going all the way back to the Kingdom of England, back to our ancestors. But when we got to that gap from William the Conqueror to Henry VII, New Jersey validates that their succession as successors to the land in lieu of acquired possession started with who? The successful invasion of William the Conqueror. All right, part of that, the land was inhabited by the original inhabitants. All right. So, in order to understand ourselves, we must understand when the infiltrator invaded, that had to be done from the outside in, not from the inside out. That came through William the Conqueror. I mean, parts of Henry VII. To secure his throne, Henry declared himself king by right of conquest. Retroactively from the 21st of August of 1485, the day before the Bosworth Field, which we have in Pennsylvania, New Jersey, there's a place called Bosworth Field. Thus, anyone who had fought for Richard against him would be guilty of treason, and Henry could legally confiscate the land and property of Richard III while restoring his own. Henry spared Richard's nephew and designated her John de la Pole, Earl of Lincoln, and made the Yorkish heiress Margaret Plantagenet, Countess of Salisbury, suzerain. He took care not to address the baroness or summon Parliament until his coronation, which was on December 25th, which took place in Westminster Abbey on 30th October 1485. After his coronation, Henry issued an edict that any gentleman who swore fealty to him would, notwithstanding any previous attainder, be secure in his property in person. Okay? Very important for you to understand that. All right? William the Conqueror conquered the kingdom of England by declaring himself king by what we call right of conquest. First of all, what is right of conquest? All right? This is called prescription. All talking about right here, this whole landmass called North America, if it was the crown and it was England, which New Jersey was a colony, going back to William the Conqueror, who invaded this landmass, all right, we must understand and put everything into perspective. Prescription is in international law is a sovereignty transfer of a territory by open encroachment by new sovereigns upon the territory for a prolonged period of time. Acting as the sovereigns without protest or other contest by the original sovereign. It is analogous to the common law doctrine of easement by prescription for private real estate. An easement is by prescription is a non-possessory use in property that you don't own. An easement is a non-possessory right to use and enter onto real property of another without actually possessing it. So when you get a mortgage to move into property and lieu of possessing it by way of the deed, you don't actually own it. Okay? You just have the right to use it. This is called the law of usury. All right? The law of usury. The doctrine legalized de jure the de facto transfer of sovereignty caused in part by original sovereign intended negligence in or neglect of the area in question. Do everyone understand that? I hope you do. Why? Let's go back to Henry VII. Henry VII took over our estate or crown estates by right of conquest. Right of conquest. From that, we get to what we call the Act of Supremacy. The Act of Supremacy. William Conquer did the same thing. He said he was the Supreme Lord. Okay? This is nothing new. The Act of Supremacy are two acts passed by the Parliament of England in the 16th century that established the English monarch as head of the Church of England. Two similar laws were passed by the Parliament of Ireland, which established the English monarch as the head of the Church of Ireland. In 1534, a 1534 Act declared King Henry VIII and his successors as the supreme head of the Church, replacing the Pope. The first act was repealed during the reign of the Catholic Queen Mary I. The 1558 Act declared Queen Elizabeth I and her successors supreme governor of the church, a title that is in the British monarch still holds. This is called a regent. This is called a regent, okay, or viceroy, or a minister. Royal supremacy is specifically used to describe the legal sovereignty of the king, i.e., civil law, over the law of the Church of England. Okay? So the first supremacy act over the crown, all right, in lieu of Roman Catholics, by Henry through the right of conquest by Henry VII, who was the father of Henry VIII, was passed and November 3rd, 1534, by the Parliament of England with a de facto king, which was one of the first major events in the English Reformation. Okay? It granted King Henry VIII of England and subsequent monarchs royal supremacy and stated that the reigning monarch was the supreme head of the Church of England. Okay? The Church of England. Y'all better listen. The act declared the king was the only supreme head of earth of the Church of England. Hear that? The only supreme head on earth of the Church of England. And the crown still enjoy all honor, dignity, privileges, jurisdictions, privileges, authorities, amenities, profits, commodities, and to that said dignity. Okay? But this is by an act of supremacy by his fathers by right of conquest by way of prescription of sovereignty, which is somebody acting as a sovereign and it not be intested by the true sovereign. Does that make sense to everyone? Please give me a thumbs up in the chat. Please. So, under the authority enacted by the Act of Supremacy of 1534 by Henry VIII, son of Henry VII, who took over the English crown and the English government, sitting here in New Jersey in 1702, going all the way back to Alfred the Great and his predecessors before him, because the government was immortal, all right, indefinite by way of the personification of the king, personifying crown land, which is intel for those heirs who, for the born, the unborn, and yet to become, all right, it's our obligation to make sure that there is, in fact, a de jure king, all right, but yet we allow some de facto king, the son of a de facto king, to overthrow our kingdom and our government because we fighting amongst our damn self. But yet, the ancestors thought paramount to create laws to preserve what it is that we have yet to understand. And apparently, we didn't understand it until now. We just now got the full understanding when I came upon the scene. Me, son of Godfrey, the fifth count of Anjou, the fifth count of Anjou, the son of folk, the ruler of Jerusalem, until I came back to reinterpret what was interpreted wrong or wrongfully. All right? So here we got that gap in time from William the Conqueror. Let's go back to the gap in time. That gap in time. Official language, English, Anglo-Norman, French, and 1066 to 1430. Monarchs from Asherton. You see that? To Queen Anne. Do y'all see that, brothers and sisters? From Asherton to Queen Anne, that will make New Jersey Provincial Council a immortal government. A immortal government from Asherton to Queen Anne, being that she was de facto. How we know that? Let's go to the next paragraph right here. So that gap in time of the untold story, which has now been told, started with William the Conqueror's successful invasion of England, with New Jersey's qualified, since they're going to justify William Conqueror's actions, which up until this point couldn't be proven. All right? And it takes it all the way down. We wasn't even born yet, to King James, the sixth king of Scotland from the House of Stuarts, who claimed descendants of Henry VII via Margaret of Tudor, and claimed the Act of Supremacy by way of right of conquest. The completion of the conquest of Wales by Edward I, Henry III's son, in 1284 put Wales under the control of the English crown. Edward III transformed the Kingdom of England into one of the most formidable military powers in Europe. His reign also saw vital development in legislation and government, in particular the evolution of the English Parliament. From the 1340 English claim to the French throne were held pretense. But after the Hundred-Year War, here come the fight amongst ourselves, and the outbreak of the War of the Roses in 1455, the English were no longer in any position to pursue their French claims, i.e., the Iberian Peninsula, which you now call Spain, all right, on that continent except for Caladius. After the turmoil of the War of the Roses, the Tudor dynasty, ruling during the English Renaissance, and again extended English monarchical power beyond England power, achieving the full union of England and the principalities of Wales under the laws of the Wales Act of 1535 to 1542. Henry VII, eighth, oversaw the English Reformation and a daughter of Elizabeth I, reigned of 1558 to 1603. This in turn, all right, this in turn caused the Elizabethan religious settlement, meanwhile establishing England as a great power and laying the foundation of the British Empire via colonization of North America. Colonization of North America. The ascension of King James VI of Scotland and King James I, on the assumption, resulted in the union of the crowns, all right, with Stuart dynasty ruling the Kingdom of England and Scotland and Ireland. The union of the crowns came in 1603. Okay? In 1603. So we know that all this ceremonial events by way of marriage in between the House of Tudors and the House of Stuarts had nothing to do with the power and authority of the Crown of England preserved and structured by our ancestors. Going all the way back to Alfred the Great, all the way up to Edward III. Okay? Edward III. Look at the extent of the history of the English kingdom. Here on this landmass, here on this landmass, hold this thought. All right? Here on this here landmass. Why? Because the crown was sitting right here in New Jersey in 1702. So everything happened in 1707 is is off the shores of what happened in 1702, and the government that was here in 1702 was they said that Edward I did what? Edward the Third, from Edward the First to Edward the Third, transformed the Kingdom of England into one of the most formidable military powers in Europe. His reign also saw vital development in legislation and government, in particular the evolution in the English Parliament. Did y'all hear that, my brothers and sisters? This is how far we go back in lieu of that gap in history that we have forgot. Okay? That gap in history, and it all is taking place right here in North America. I didn't say that. New Jersey stated it. Right there. They're stating it. All right. They gave an illustration about a big tract of land here in North America as the entire nation, everyone said, of England. Why would they make a reference to something way over there? They're talking about right here from William the Conqueror. All right? From William the Conqueror. They said without William the Conqueror, their acquirement of land ownership would not be possible. It will not be possible. So we see the changes that Edward the First to Edward the Third made, right? Here in New Jersey, opening their foot again, putting their foot in their mouth. Edward the First passed Quint Imperatorus. All right? He passed Quint Imperatorus, and they gonna have the nerve to and reenact, based upon the legislative scheme, the impact that Quint Imperatorus had for their benefit. For their benefit. Right here. Statutes of Quint Imperatorus passed by Edward the First, son of Edward, son of Henry the Third, son of John, son of Henry the Second, son of Godfrey the Fifth, Count of Anjou, son of Folk, ruler of Jerusalem. Statute of Quint Imperatorus, since these incidents were of great economic value to the overlords, they naturally turned to the king for assistance. His response was the enactment of the Statute Quint Imperatoris Terrarum. The name of the law is taken from the opening words of His Majesty's laws concerning the buying and the selling of land. They left that part out, though. I wonder why. Okay? They left that part out. Although it is unclear from the literal reading of this statute was interpreted to prohibit the further subdivision of land. Okay? It is prohibited the further subdivision of land. But most significantly for New Jersey's purposes, I repeat, but most significantly for New Jersey's purposes, I repeat, for most significantly for New Jersey's purposes, I repeat, but most significantly for our purposes, it also gave the tenant, in fee simple, the right to substitute another in place without obtaining the permission of the overlord. The overlord was obligated to the Lord Paramount, but that will be the king. But now you have um, robbed the king based upon the fief that was given from the Lord Paramount, i.e., the king, to the overlord, overseeing the grant that he now extended to the tenant in chief or vassal in chief. These are all words we went over yesterday, and what we call capitite, which is a feudal tenure. The transferee then stood in the same position, vice versa, as the overlord, as did his transferor. This was, of course, a radical move, though, which was completely at odds with the original pyramid like structure of how it was established in feudalism going back to William the Conqueror. Thus was created what you have now, the modern fee simple estates and land. Because the tenant in fee simple was now the owner in fee simple, his relationship was the transferor and transferee were considered to be allodial, the opposite of how tenure and feudal tenures were actually conveyed. And the actual way they were conveyed was through a source granted by an instrument known as a title to a deed of land by the king. Because they said it. Of course, the king still remained as the source of title to land. So where the hell is the king? Where is the king who is the source to all title to land? These are questions that New Jersey has to answer. If you know so much about Edward III. 104. Decline of the collapse of the feudal system. As noted above, the Statute Queen of Praetorius marked the beginning of the end of the feudal system. Its decline was abetted by change in social economic conditions, as well as by certain legislative enactments. For example, the statutes of tenures, most feudal obligations were converted into free income and socage, which amounted in practice to the payments of rents and cash. This is what you're doing now, right? The statute of tenures were passed by Charles II in 1660. It's called the statute of abolition of tenures. Okay? In New Jersey, the state statute Queen of Praetorius has been reenacted. Did you hear that, brothers and sisters? How are they going to explain that statement? You're going to take somebody else's legislative statute, preserved for them, their posterity, and their posterities, and reenact that law as part of your statutory scheme regarding your right to now acquire real estate, which came through the successful invasion of who? Everybody said William the Conqueror. Now, how stupid can you be? Especially when I'm dropping it like this on live YouTube. Imagine me in that trial court dropping it like that. While this law may seem archaic and unnecessary in contemporary society, it must be viewed in the context of a legislative scheme which sought to eradicate the last vestige of feudalism in New Jersey and to prevent its establishment at some future date. Accordingly, other sections of Title 46 serves to abolish feudal tenures, to eliminate feudal services and incidents in favor of free and common socage, and to provide that conveyances from the state shall be allodial and not feudal in nature. How the hell is going to be allodial and not feudal in nature when there's tenures on that allodial land? Allodial means free and clear of any encumbrances. So how are you going to explain that statement? It is true that the feudal system never really took hold in America. So why are you practicing feudalism, known as fee simple? Because that is a form of feudalism. Yes, it is. It is true that the feudal system never really took hold in America because it was dying out in England by the time of colonization occurred. Okay? Nevertheless, some of its remnants can be found in the references to payments of 40 beaver skins yearly in the original grant of New Jersey from King Charles II, the Duke of York, in 1664. At any event, the legislature believed it was prudent to take measures to guard against the institutions of feudalism in the state. As a result, feudalism has no place in New Jersey today. That's contradictory to what you just said up here. It's just contradictory to what you just said right here. Because New Jersey was formerly a colony of the Crown of England. The history and development of our entire legal system, including our system of land ownership, has its roots in England. For our purpose, the development of land ownership began with the successful invasion of feudalism. The successful invasion of feudalism, under feudalism, by the process that was started by William the Conqueror. So how all of a sudden now you're trying to eradicate something that your whole system is based upon? Does that make sense to everyone? Please give me a thumbs up in the chat line. Henry VII, right of conquest of the Kingdom of England, pursuant to the Act of Supremacy under the authority of the Crown, all right, as head of the Church of England. All right, this was reinstituted by the Second Statute of Repeal, or the See of Rome. The Second Statute of Repeal, or the See of Rome Act, in 1554 was an act of the Parliament of England under uh, Queen Mary I and King Philip in 1555, following the first Statute of Repeal of 1553. The first statute had abolished all religious legislation passed under Edward VI, and the second statute built on its abolishing all religious legislation passed against the papacy from 1529 to the fall of the Cardinal Thomas Wolsey and Henry VIII's reign. It was supported by the landed classes as allowed them to keep the monasteristic land which they had acquired after the dissolution of the monastery. Okay? This brought on the Act of Supremacy of 1558 by who? Queen Elizabeth I, the daughter of Henry VIII, the son of Henry VII, the one who overthrew the English crown by what? Prescription of sovereignty, by an act of supremacy. The Act of Supremacy, sometimes referred as the Act of Supremacy of 1559, is an act of the Parliament of England which replaced the original Act of Supremacy of 1534, passed by Henry VIII, and passed under the auspices of Elizabeth I. It was issued by Elizabeth's father, Henry VIII, which arrogated ecclesiastical authority to the monarchy, but which had been repealed by Mary I, along with the Act of Uniformity in 1558. The act made up what is generally referred to as the Elizabeth Religious Settlement. The Elizabeth Religious Settlement, and this is where the process of naturalization under Calvin's case came from. Okay? The Elizabeth Religious Settlement is the name given to the religious political arrangement made for England during the reign of Elizabeth's reign in 1558 to 1603. The settlement, implemented by 1559 to 1563, marked the end of the English Reformation, going back to the Kingdom of England That's why it's over here located where you see at in 1558. Look at the map. The location of the government now in 1558 to 1707, which was a result of the House of Stuarts, and the House of Tudors overthrowing the Kingdom of England, the government of England, as a result of the heirs fighting amongst themselves. Okay, in which the government was actually located over here. Okay, as a result of this gap in the history that we have now forgotten, but now we have now remembered and have now acted upon that memory. Okay? We must comprehend our estate and the laws pertaining to our estate. Why is this so? Surname and closer. Surnames are the purpose and intent while the Doomsday Book was prepared. In England, the introduction of family names is generally attributed to the preparation of the Doomsday Book in 1086 following the Norman conquest. Okay? New Jersey said their way of acquiring the land ownership was the successful invasion of England by William the Conqueror in what we call the Norman conquest of England. All right? This is the purpose intent for why the Doomsday Book was created based upon those family names who were the actual heirs prior to the conquest of what we call here here in what we call England. Okay? Evidence indicates that surnames were first adopted among the feudal nobility and gentry and slowly spread to other parts of society. All right? Before the name of their villages, pardon self, and society. Some of the early Norman nobility who arrived in England during the Norman conquest differentiate themselves by affixing "day of" before the name of their village in France. This is what is known as territorial surnames, a consequence of feudal land ownership. By the 14th century, most English and most Scottish people used surnames in Wales following the unification of Henry VIII in 1536. We know Henry VIII came by way of Henry VII, who got their right of inheritance by way of conquest through the acts of supremacy. Okay? So they were not, in fact, heirs. If you got this name and don't trace it back to the Plantagenet, Cadet branches, the Yorks and Lancasters, you might have a problem with your inheritance, my brothers and sisters. Okay? You might have a problem. Because we know the Doomsday book, it's called the heading or the capitite. All right? A caput. The word, where we at? We know it was actually published in March 15th, 1783. It was actually published. Prepared in 1086, but published in 17. Let's look at the publication. Let's do that before I move on. By Abraham Farley. Farley pursued the task with a single-minded devotion born of a long involvement with the public records and Doomsday Book in particular. One of his close associates during the project was printer John Nicholas, inheritor of William Boyle's London printing press. In 1773, he developed a special record typeface that was used in the published edition to represent as closely as possible the script in Doomsday Book itself. Ultimately, Farley's edition of Doomsday was completely completed by March 15th, 1783. March 15th, 1783, the first publication of the preparation of the Doomsday Book that was prepared in 1086 by William the Conqueror concerning the Doomsday Book in lieu of the land that was recorded and surveyed on the what we call the Great Survey Book. Okay? The Great Survey Book. Where was I at? All right, let's see. So in closing, let's come here. I do have this book, the Doomsday Book. Let me just show you a picture of it. Picture of my Doomsday Book, not the original Doomsday Book, but nonetheless, let's see. Wait for that. Come on. Slow down. Come Wait with you in a second, my brothers and sisters. Doomsday book. What's up on my computer? Image. Let's see. That's not it. Where is it at? Let me show you this first. I you come on. I don't know what's going on with my photos. All right, here we go. All right. I typed in last night. I typed in last night on my computer. I don't know why it popped in my head. Can you quiet the title on the Lodio land? That's what I looked up. All right. So I'm showing you, brothers and sisters. But this is what I'm trying to do. In closing. This is what I'm trying to do. Can you quiet the title on the Lodio land? This is what AI had to say about it. A Lodio title. This means that land owned completely by. Hold on. Here we go. Quiet the title on the Lodio land. Quiet title on allodial land. Okay. A quiet title on allodial land. Let me just show you. Come on, share. Quiet title on allodial land refers to a legal action taken to establish a clear ownership of a property that is held under a allodial title. Everybody see that? Quiet title on allodial land refers to a legal action taken to establish clear ownership of a property as if held under allodial title, essentially meaning the land is owned outright without any feudal obligations to a higher authority. By filing a lawsuit to remove any potential claims or clouds on the title, allowing the owner to fully exercise their right to the land, and this process is essentially the same as a standard quiet title action, but with the specific context of the allodial ownership. Everyone see that, right? Everyone sees that. So this is the process that New Jersey should have took if New Jersey owns the land allodial. Okay? This is what they should have did. Allodial title, this means that the land is owned completely by an individual without any obligation to any higher authority, like a feudal lord, which is the opposite of feudal system, where land is held under a lord ownership. Quiet title action. A legal proceeding where someone with a claim to land can file a lawsuit to establish their ownership right, and remove any potential challenge to the title, essentially quieting any competing claim. While it might not be needed on allodial land, even though allodial ownership implies absolute ownership, there could still be situations where a title dispute arises due to errors in documentation, boundary issues, or boundaries issues or conflicting claims from other parties, making a quiet title action necessary to clarify the ownership. All right? Important considerations. Important considerations. Jurisdiction. While the concept of allodial title exists in application, varies based on the laws of each jurisdiction. Evidence is required to successfully quiet on a allodial land. You hear that? Did y'all hear that? To successfully acquire the title on the land, the owner would need to present strong evidence of their ownership, including deeds, surveys, and proof of possession. Now, how do your king do this? How do I do this? Gotta understand chess, my brothers and sisters. All right? Gotta understand chess. And King Edgar is the greatest chess player, my brothers and sisters, which I'm the reincarnation of. All right? So how could I prove ownership of the allodial land where everybody else has making a claim in the land that is soon to be allodial by way of some fee simple estate? How do I prove that the land is allodial and that it rightfully belongs to me, and that New Jersey does not own the land allodial because it doesn't rightfully belong to them? How do I accomplish this in one task? All right. Where's my evidence? Let's see. In closing. Once again, I hope you judges, lawyers, attorneys, and anybody else who's concerned has something to do with this case to really consider what it is that you have stepped into. All right, because this is in fact Doomsday Book 2025. Thus saith I, your Lord. So, in closing, where's my proof? This is the proof I'm using. New Jersey Revised Statute 46:3-6, gift grants and conveyances by the state is a lodio. All gift grants and conveyances made prior to and after July 4th, 1776 of any estate of inheritance by letter patent under the great seal of the state or any other manner by the state, by the legislators thereof, or by the commissioners or agents or forfeiters of the state, or by other lawful incompetent authority under the state, shall be and remain allodial and not feudal, and shall forever be and continue and free of allodium, only forever discharged of all feudal tenures and interests thereof, and all other services whatsoever. So if this is the case, New Jersey has no claim, and the lawful conveyance to the king is warranted by 46:3-2, which we'll close out on. Forty-six country that's two certain tenures and holdings turn into free and common soakage. The tenures and honors of manors and lands, tenements, or heritages, or a state of inheritance, as the common law held either of the King of England or of any other person or body politic or corporate at any time before July 4th. That means New Jersey is excluded. Any state within the Union is excluded. The United States is excluded. Great Britain is excluded because it didn't say King of Ireland or Scotland. It said the King of England. Prior to 1000 July, prior to or before July 4th, 1776, it declared by Section 3 of an act entitled An Act Concerning Tenures passed February 18th, 1795, is to be turned into free and common soakage from the time of their creation and forever thereafter, and should continue to be held in free and common soakage, discharged of all tenures, charges, and incidents enumerated in said Section 3. Why? Because no subinfeudation is allowed. No alienation is allowed. What is subinfeudation? In closing, we are forced to be reckoned with. Subinfeudation. In English law, subinfeudation is a practice by which tenants in chief or vassals in chief are capitite, which means the head. Each head is counted per capita, which means per head. English law, subinfeudation is a practice by which tenants holding land under the king or other superior lord carved out new and distinct tenures in their subleasing or alienating as part of their land. The tenant was termed Mesne's lord, which regards to those holding from them an immediate tenant being tenant in capitite. The lowest tenant of the all was the freeholder, now called commissioner, or as he was sometimes termed, tenant prevel. The crown, who in theory owned all land, was what? Lord Paramount. Did you hear that? Lord Paramount. The great lords looked with dissatisfaction on an increase of subtenure. Accordingly, in 1290, a statute passed, Quint Impetuous, to whom allowed the tenant to alienate whenever he pleased, but the person to whom he granted the land was to hold it the same as the immediate lord. Okay? As the immediate lord. And one more thing I want to look up. Lord Paramount. What is Lord Paramount? Not landlord, but Lord Paramount. A lord paramount is a term of art in feudal law describing an overlord who holds his own fief from no superior lord. It does describe a person who owes a lordly title, owing no sokish or feudal obligations such as the military service. This was distinguished from a man's lord who holds owner fief from a superior. That's just what you read in New Jersey Revised Statute Title 46, colon 3-2. Okay? That's just what you read. The term paramount derived from the Anglo-Norman paramount means up above or par amount, atop of the mountain, i.e. pyramid. It was used to indicate the lord who was the highest authority for any given location. Similar terminology was used for the vassal of Manet's lord, who was considered a paravel from a par of val and a value. This latter term, however, was confused by later lawyers with avail, and since of help, assistance, and profit, and was eventually applied only to the actual occupier of tenants who worked the land themselves. Instances. Generally speaking, under English law, once again, after 1066 Norman conquest, only the sovereign, the king or queen, was truly the lord paramount in a larger sense. All other legal titles to land was held through them, particularly after the abolition of most usual feudal titles and obligations under the 1660 Statute of Tenures Act passed by Charles II. So this is what you read right here. Page 4. Right here. All right? It's right here. Decline and collapse of feudal system. As noted above, the statute of Queen Victoria marked the beginning of the end of the feudal system. Its decline was abetted by a change in social and economic conditions, as well as certain legislative enactments. For example, the statute of tenures, most feudal obligations were converted into free common social, which amounted and practice of paying rents. All right, which is being done right now. New Jersey's statute of Queen Victoria has been reenacted as a part of our statutory scheme regarding real estate. While this law may seem archaic and unnecessary in contemporary society, it must be viewed in the context of a legislative scheme which sought to eradicate the last vestige of feudalism in New Jersey and prevent it from establishing it in some future date. So, as you can see, New Jersey reenacted as a legislative scheme what was enacted as a legislative law by our ancestors under the plantation crown, but for us, in lieu of our preservation, for the states which were sure to come when that primogeniture heir was to come of age, i.e., proof of age. Okay? And I'll close out on that. Proof of age. Once again, you like what you're hearing, like, share, subscribe. Once again, donations are accepted, free and common focus to the Third Tip English Church of England or $Clifford Jefferson L. We really appreciate your assistance. So, in closing, proof of age. Every one of you must show proof of age from that gap of time, all right, from 1066 to the present, which is the mechanism needed to prove an heir legal age to inherit his estate. Okay? To inherit your estate, proof of age is required. The earliest surviving proof of age dates from 1272, either at the very end of Henry III's reign or at the beginning of Edward I, who passed Queen Imperatrix and did donors conditional the bus. In the early days, there was no fixed oversight for hearing, and while the Estrada and his staff was holding them from the start, so also was the court of the King's Bench, also called the court of the Career Regents, which was also called Wittemont or Witten, and pre-periodic area courts. Likewise, witness and evidence was often not recorded, which means that for these we now for these we know that they remember at birth or baptism, but not necessarily why. The mechanism as it was to remain appears to have been codified by the 14th century. Proof of age inquiries, when being held into major landowners' scions, and nobility could involve at greatest extent hundreds of officials, thousands of jurors over many counties and multiple jurisdictions being involved. Proof of age hearing. Purpose of proof of age inquisition was to establish the date of birth and thus the age of the feudal tenant in chief, often as part of the overall inquisition post-mortem legal process, which would establish whether he should be taken into as a ward, i.e., a vassal, i.e., an indentured, all right, until you can come into the age being able to bear the inheritance of your estate at what they call the age of majority, and this is now determined by your memory. Okay, it's determined by your memory. Let's see. That's right there, right here. It says right here. This was a period when mandatory certification of birth was not a legal requirement. Yet knowing when heirs to feudal estates were born was of great importance as it could impact financially. If a person's father died before they was old enough to inherit, then they could be taken into wardship by the king in his estate on the royal estate. As such, proving one's age accurately was, according to Sue Sheridan Walker, of the utmost legal, social, economic significance and efficient working of land law. Because there was no requirement to record births in writing, it was necessary to rely on what? One's living memory. Once again, one's living memory. So if you remember who you was, going back to time immemorial, based upon English common law, going back to time immemorial, then we do have a place for you in our estate, known as Crown Land, which are estates of the crown prepared by our ancestors, ready to be um, uh, converted, transferred, and preserved in this present day. So with that, I hope you enjoyed today's lesson, Doomsday Book 2025, Day of Judgment, Thus says the Lord. And I hope you all can comprehend what's being said to you because your very salvation depends upon that. And with that, I'm going to greet you as I always have greeted you, and that's in peace and love.